I'm now being joined by Advocate Shadan Farasat, who was appearing in court for one of the petitioners. Sir, how do you see this contour of this verdict, particularly? What does this mean for the reservation policy, and how do you see the states now implementing these policies?
See, one aspect is clear that the amendment has been upheld, so by a majority of 3:2. But I think there are very clearly divergent views of what is the meaning of reservation and equality in the Constitution between the 3 judges and the 2 judges. And that debate itself in other reservation matters. This is, of course, the EWS constitutional amendment has been upheld. And the exclusion has also been upheld by a majority. But that debate will continue in future reservation matters, and I think the dissent is a very strong dissent on the logic of the Constitution, on the logic of what is meant in the Constitution, what is the anti-discrimination principle.
If you could explain this for our viewers who do not understand legal principles here. The court, of course, by a 3-2 majority has upheld the amendment, but there are several observations involved that are questioning the extent of reservation, how long can reservations last, whether there should be some sort of a review of the methods of identification, etc. At the same time, there's a political war erupting over exclusion of OBCs and SC/STs and discrimination as such. So what does this really mean for a layperson?
See, so what has happened is there were 2 fundamental questions before the court. Question 1 was whether on economic criteria alone reservation can be granted in the Constitution. So on that, all the 5 judges are agreeing that yes, it can be granted on economic criteria alone. Then there was a second question, and the second question was whether the exclusion of the backward classes, that is SC, STs and OBCs from this EWS, in effect making it a forward class economic reservation, was that constitutional or did that violate basic structure? On the second question, 2 judges, Justice Bhatt speaking for himself and for the Chief Justice, have dissented and said that did violate the basic structure because it violates the anti-discrimination principle because they are the poorest. In fact, factually also the backward classes are the poorest. So even if you take economics as a sole criteria, why exclude the ones who are the most deserving? That's really the argument which we had. That was our argument, and that has been accepted by the 2 judges in toto. Now, the question whether how this will play out in other reservation matters, I think the dissent is a very strong dissent. It espouses a very egalitarian vision of the Constitution. So I think in other reservation matters, it's equally possible that the dissent will have more impact than the majority view today. But of course, as far as the amendment's constitutionality is there,
what about the issue of 50% ceiling limit as such? Because so far, every judgment, every verdict, every opinion has been you cannot cross that 50% limit. Now what happens?
So on the 50%, again, the majority has said that the 50% is not a rule of basic structure, because that by itself, 50% by itself envisages exceptions, and if something envisages exceptions in the rule itself, then how can it be a form of a basic structure? That's effectively the majority. Justice Bhatt seems to have, at least what he read out in court, seems to have expressed some reservation on that aspect, not a complete disagreement, but some reservation. So that exactly the extent of his reservation on that aspect we'll know when we read all the opinions.
Thank you very much, Mr. Farasat, for speaking to us.